but a very warm welcome from myself. For those of you who don't know me, I am Andy McDonald. I'm the Member of Parliament for Middlesbrough, Labour MP, and I've been a member of the Britain-Palestine APPG for some time now. So I'm really honoured to be asked to chair this meeting. And I know we've had a lot of interest from people from a wide range of organisations, and indeed from other countries and other colleagues here, perhaps from Ireland and from Belgium, amongst many others. But a very warm welcome. The purpose of our gathering today is to consider and hear about the report from Defence for Children Palestine International, I would think. And the title of the report, unless somebody corrects me if I get this wrong, Miranda, is Arbitrary by Default. So I'm looking forward to hearing about that, about how Palestinian children are treated in the course of their passage through the Israeli military court system. And just by way of example, I had the pleasure, Joe and colleagues who were kind enough to take me to Palestine some years ago, and I saw those conditions at first hand, and you know, I was aghast at what I saw and the way in which children were treated. And of course, it comes today. We're gathering today in an important week, certainly in the UK Parliament, when we've had not only the anti-boycott bill have its first hearing. I got to say that my party declined to give the bill a second reading and had a reasoned amendment to it. It is a truly dreadful bill. And then, of course, that was followed by a discussion and an urgent question around the terrible events in Jenin, as we saw this week. So it is absolutely apposite that we should meet and discuss this today. I won't say too much more, but just in case I forget, I do want to thank Caabu, the Secretariat to the APPG, for the work that they continue to do and support us as we try to deliberate these vexed issues. But I think what we're going to do now, and of course, colleagues, please do correct me, but we're going to hear from 3 speakers in total. The first of our speakers, it will be Brad Parker from Defence for Children International Palestine, who's a senior advisor and policy and advocacy. We'll also hear from another Defence for Children advocacy officer, Miranda Cleland, and then finally from Rika Barnard from PSC, the Deputy Director. I don't know whether she's been able to join us yet. I'm not quite sure about that, but hopefully soonest. But there we are. So without further ado, could I hand over to Brad? I think we're going to hear from people for what, about 10 to 15 minutes, Brad, and then we'll go through. So over to you, Brad. Thanks very much.
Thank you, and thanks to everybody that's here. Thanks to Caabu and James and PSC for helping coordinate this and make it easy for us to present this report and the work that we do to you all. So I'm Brad Parker. I've been with DCI Palestine for the past 10 years. I'm a US trained attorney and have worked leading the international advocacy, legal advocacy for DCI Palestine for those 10 years. And this latest report is, has been years in the making. A lot of the issues that it included are the things that many of you have probably heard about for years. This isn't a new issue. This is a really sustained, perpetuated issue around ill treatment, denial of fair trial rights of Palestinian children detained and prosecuted in the Israeli military courts, which I know, as Andy mentioned, he's seen firsthand, and I know some of the others here have seen as well. So I wanted to just give a bit of grounding on the situation of international child rights globally, just what the international norms are, because I think sometimes there are some misconceptions around the specific protections that are obligatory under international law, both humanitarian law and human rights law, because I think that sets up the analysis in the report, which finds, that essentially any Palestinian child prosecuted in the Israeli military court system amounts to arbitrary detention because of the arbitrary nature of those arrests, those detention, the denial of fair hearing and fair trial rights. So I'll get into more detail on that, but from the outset, this is an issue that DCI Palestine has been working on since 1991. It's why we were founded, to provide legal aid to Palestinian children charged in the Israeli military courts. So, this is the bread and butter, you could say, of the work that we do, that our attorneys do. It's our reason for existing. We've obviously expanded over the years, but this work is really core to who we are as an organization and the issues that we focus on. So, I think some of this folks will know, right? International human rights law, regardless of guilt or innocence or the severity of an offense, children have special protections, as well as, all the due process rights that one would expect. The two basic principles of international juvenile justice norms are best interests of the child must be a primary concern in decisions that affect them, and that detention must be used only as a measure of last resort. And then if it's used as a measure of last resort, it's for the shortest time appropriate. So all of that is sort of the guiding piece that makes international rights related to children kind of specific in the deprivation of liberty context. Beyond that, right, that all the things that all persons entitled to a fair public hearing, and same as adults, hearing by a competent, independent, impartial tribunal. And then, the other big one is the absolute prohibition on torture and ill treatment. Right? Absolute meaning no exception. Those are sort of the big pieces. There's non-discrimination protections, which comes up in the arbitrary detention piece in the context of Israel. And then some of the other rights and protections, this is one that is commonly misunderstood in the context of Israel military law, Israeli civilian law, but the age of majority, right? Under international law, a child is any person under the age of 18. Under Israeli civilian law, under Israeli military law, the age of majority, right, is 18. So a child is essentially anyone under 18 years of age. Though under the military law, there's some sort of specific carve-outs in practice, the way that the law applies, but generally anybody under 18 is treated as a child. Again, absolute prohibition on torture. There's absolute prohibition on arbitrary detention. International fair trial guarantees require notification and reason for arrest at the time of detention. Presumption of innocence, right against self-incrimination, the right to legal counsel, and in particular related to children, the presence of parents during hearings, interrogation, sort of any interaction with the state. Parents have a right to be present generally. And then again, just to sort of, none of these rights can be sort of accessed, right, if you don't have the right to a competent, independent, and impartial authority in a fair hearing according to law. So that's the overarching piece, right? So what our report does, so, as I said, it's been years in the making. We set out several years ago essentially trying to build the case for the conclusions that we draw in the report. The way that we did that was in 2015, we saw a resurgence of the use of administrative detention against Palestinian children. So in 2011, we were essentially successful with international pressure and international efforts to get the Israeli authorities to stop using administrative detention or kind of detention without charge against Palestinian children. In October 2015, that changed. Israel started to use the practice again against children. So we said at that time, we know this is arbitrary detention. We're going to start sort of pushing cases and complaints and petitions to the UN Working Group on Arbitrary Detention, see what the opinions are that they sort of provide back, and then use that as a basis for really looking at and examining the entire Israeli military detention system, the Israeli military court system under sort of this arbitrary detention framing. So what the context is, right, Palestinian children in the West Bank, like adults, they face arrest, prosecution, and imprisonment under an Israeli military detention system. Inherent in that Israeli military detention system, Israeli military law system, right, it denies basic rights just inherently. Military laws applied to the West Bank since 1967 when Israeli forces occupied the territory. And what you have, right, as a basic setup is the military law applies to Palestinian population, while Israeli citizens, Israeli settlers living inside the occupied West Bank, they have the benefit of Israeli civilian law. So on its face, right, a violation of non-discriminatory norms in international law, where Israel operates two separate legal systems in the same territory. Just a note on Jerusalem. While East Jerusalem is considered part of the occupied West Bank, Palestinian children who live in Jerusalem generally fall under the Israeli civilian law and the Israeli youth law. So the legal distinctions there between East Jerusalem and the rest of the West Bank track back to 1967 when Israel essentially annexed, right, East Jerusalem and treats it as part of Israel. So the evidentiary basis for this report is based on 766 affidavits that we took from West Bank children between 2016 and 2022. The main sort of ill treatment findings that we're known for putting out shows, very consistent to previous years, previous reports, things that, not only us as DCI Palestine have been reporting, but other organizations, the UN agencies, a whole range of folks. So it shows 3/4 have endured some form of physical violence following arrest. 97% of children had no parent present during interrogations. Over 2/3 were not properly informed of their rights. Right, all of these things sort of play into due process rights, fair trial rights, and then another sort of the other two big statistics that stand out is that Israeli forces did not inform children of the reason for arrest in over 85% of cases, and in no case was a child or their family presented with a warrant, right? Because soldiers arrest on suspicion, overwhelmingly, in almost every case. So when we talk about arbitrary detention, what does that mean? It's essentially kind of an elevated analysis, right? We're used to talking about the ill treatment. We're used to talking about torture, due process denials. So when we're talking about arbitrary detention, we're looking at those individual rights denials together, right? That then give the detention an arbitrary character, an arbitrary nature. So the underlying violations that we see, right, play into that overall analysis of arbitrary detention. So as I said, the United Nations Working Group on Arbitrary Detention is really the key international actor in setting this normative status for what amounts to and what is considered arbitrary detention. It's an international body of experts with a mandate to investigate alleged cases, and it's sort of adopted this criteria to help assess individual complaints that they receive. So there's 5 categories there. I'll just sort of mention them briefly to give some context, but in the report, they're sort of detailed. Category 1 is when it is clearly impossible to invoke any legal basis justifying the deprivation of liberty. So this can be, when a person's kept in detention after the completion of their sentence. In the context here, it's administrative detention, right? It's detention without charge. That's sort of what we're talking about with category 1. Category 2 is when the deprivation of liberty results from the exercise of rights or freedoms guaranteed by specific articles of the Universal Declaration of Human Rights, and then some specific articles in the International Covenant on Civil Political Rights. So this comes down to freedom of expression, freedom of association. So if somebody's being detained, and we've had cases of this with Palestinian children, a Facebook post or a photo that they liked on Facebook or social media, right, is the main reason that Israeli forces have detained that child, interrogated that child, and maybe charged that child, then that sort of falls into category 2. Category 3 is when the total or partial non-observance of international norms relating to the right to a fair trial is of such a gravity as to give the deprivation of liberty an arbitrary character, right? So this is, one of the, I think when we talk about where does arbitrary detention sort of fall when we're talking about the evidence base that we have as DCI Palestine and Palestinian children in the military courts, we're, I think, systematically looking at category 1 and category 2. So I'll just sort of share a bit more detail on that. So category 3, again, is when the total or partial non-observance of the international norms related to a fair trial sort of create an arbitrary character to the detention. So this one is fairly straightforward. And for the United Nations Working Group on Arbitrary Detention, there was really no question. And this is because Israeli military courts are not independent or impartial, right? You have military court judges, prosecutors, part of the Israeli military. The judges are dependent on superiors for promotion. Overwhelmingly through the decades, the military courts are considered to not be independent or impartial, simply due to that fact. More broadly, military courts are presumed not to be adequate courts, tribunals to try civilians, right? And that they're only adequate for military personnel. So that's really inherently the main piece for why prosecution of Palestinian children in Israeli military courts amounts to arbitrary detention. Some of the other factors that play into this assessment is that there is no absolute prohibition on torture, cruel, inhuman, or degrading treatment, right? Again, this is meant to be an absolute prohibition in international law. It's not something you can pick and choose to apply or not. Under Israeli law, there's still sort of an open door for torture and cruel, inhuman, degrading treatment in certain contexts. So that also chips away at the ability to provide a fair hearing, fair trial, and due process. The other factor in this consideration is there's no parents present. And then also just sort of inherent in Israeli military law, there's no right to for a child to have a lawyer present during interrogation, right? There's a general right to counsel, but they're prohibited the right to a lawyer during interrogations. Just to touch on category 1, and again, all of this is detailed in the report. Before I pass it to Miranda, category 1, again, no legal basis to justify the deprivation of liberty. In part, administrative detention, is exactly what this specific category of arbitrary detention is meant to cover and address. Beyond that, there's also the fact that soldiers arrest on suspicion and that warrants are rarely issued, combined with the fact that children and their families are not informed of the reason for arrest in the overwhelming majority of cases. Right? So that just gives you kind of the bullets of why. And I think what we've gathered over the years, we know the ill treatment is systematic, institutionalized, widespread by Israeli forces arresting Palestinian children from the West Bank. Amendments to the Israeli military law over the years have really been cosmetic, right? They haven't adjusted practice or resulted in any increased protections for children that are detained by Israeli forces. And that's because the system isn't intended to actually hold individuals accountable for specific acts, right? It's really a means to control an occupied population. I think everybody's probably familiar with this, but we'll just say it to close out before I pass it to Miranda. If you arrest hundreds of adolescent boys from their homes in the middle of the night every year, their fathers, their mothers, their families can't protect them. You do a lot of work to chip away at the community that child's a part of, and fragment and sort of control that community. So where we see these children being targeted for arrest are in communities that are near settlements, near military bases, really kind of communities, Palestinian communities near, what we could say is occupation infrastructure. That's where these children are being targeted, and that's why they're being arrested. And the spike sort of in arbitrary detention, I think is increased as there's been sort of more or less attention on the issue internationally. So looking back to 2011, when Israeli forces felt enough pressure that they had to essentially stop holding children under administrative detention orders. Right now, we're seeing the highest number of children detained pursuant to administrative detention orders since the practice was reinstated in 2015. So I think at the moment we have 16 or 17 cases of kids in administrative detention that we're tracking. So I'll stop there and pass it to you, Miranda, to sort of zoom in on specific cases.
Well, thanks very much for that, Brad. I think the word that sort of shouts out to me from that last section of your report was sinister, just how targeted this is. And I just shuddered to think about the psychological damage that flows therefrom. It must be off the scale for not just for the young people concerned, but for their families and communities. We're going to pass over now to Miranda. So over to you, Miranda. I would say if people want to raise things in the chat as we go along, if we can pick them up. Otherwise, we are going to have a Q&A at the end. But Miranda, over to you.
Thank you, Andy, and thanks, Brad. First, I'd like to show just a short video where you'll hear from a Palestinian boy named Mohammed Mansour, who was first detained by Israeli forces when he was 17 years old, and he was held in administrative detention for more than a year. So kind of after hearing, about all of the international legal obligations, we think it's really helpful to sort of zoom in and hear directly from a Palestinian child on what their experience has been like in the Israeli military detention system. So I'll show that. That's just a short video, and then talk a little bit more about his case afterwards.
اسمي محمد منصور. اعتقلت للحكم الإداري وكان عمري 16 سنة، وأنا من مدينة جنين. فترة الحكم عندي 16 شهر، يعني هذا 16 شهر كلها كانت يعني بدون توجيه لتهم. الحكم الإداري يعني حكم من أصعب الأحكام، انتم مش عارفين انت تروح، هاي اول شيء. انتم جزء تجددوا لكم هذا اليوم تجديد ثاني او ثالث او رابع، تفرقش عندهم يعني قد ما يجددوا لك. انت مثلا مؤبد بروحش وانت مش عارف انت تروح، وكل صار عندك ملف سري انت، وانا بقدرش اقول لك شو عليك فيه بالملف السري وشو موجود داخل الملف. يعني كنا متوقعين انه يتم الافراج عنه بما انه فيش عنده لا تهمه ولا اعتراف ولا اي حدا شاهد عليه ولا اي شيء، مجرد انه خلاص يعني القهر اللي فيها انه خلاص في ملف سري وبس، ما فيش شيء ثاني تقريبا. وانا يعني لابس حتى كيف بجهز بهذا الاغراض وهيك بدي اودع وقاعد مع الشباب، انه مره واحده بنادي علي التنظيم بقول لي هاي في ورقه تجديد اداري لك. جددوا لي يعني 4 شهور اداري، يوم نفس يوم ترويحتي. خلص يعني انه بنطلع نجيبه يعني نستقبله من سجن مجده. فمتفاجئ انه هو بيتصلوا على مدير سجن مجده انه تم تجديده، فكانت هون الصاعق على امه اكثر من هي اللي استقبلت المكالمه، وقالوا لي خلاص لا هذا اخر تجديدي لك، مستحيل انه يجددوا يعني مثلا اخرى لك بزياده بعد هذا، يعني هذا اكيد انت راح تروح. زي هيك صاروا يحكوا، ما توقعتش انه اخرى مره في اخرى تجديد بعد الثاني. بتصاير المحامي كل كمان جددوه اخر 4 شهور، في كمان تجديد اخرى اداري 4 شهور، فكانت برضه يعني صعوبه اكثر لسه. قال لي انت اليوم روح يلا روح البس. رحت لبست توعية وودعت مثلا اصحابي اللي بمشي معهم، ودعت الناس اللي حوالي هيك طلعت خايف انه تجرد دوخه مره يقول لي ارجع خلاص ارجع من اول وجديد بدنا نجدد لك. يعني حتى واحنا نستنى فيه بالفتره الطويله اللي استنيناها بعده في خوف، يعني في خوف عندك انه يقول لك في تجديد. حتى وانا بعدني شايفهم وضايل مقاطه واحده دمرق عنها بكيت متوتر، كنت هسه سكروا المقاطه ويرجعوني من اول وجديد لكن متوتر. كيف وصلت قطعت المقاطه خلاص انه ارتاح الواحد. لما وصل بعدني خايف، لما طلع بريت المعبر ووصل عندي وحسيت فيه ومسكته وحضنته حسيت انه حريه ما قبل الان.
أنا عبد الرحمن محمد أبو الروم، والد الطفل أنس أبو الروم المحكوم بالإداري. أنس بقى فترة تقريبا 16 سنة وشوي عمره، وحطوه إداري على شو بنعرفش، ملف سري. وبنتنا نحاول نعرف شو الملف السري لغاية الآن مش معروف. أول زيارة رحنا زرنا عليها هو حتى محبط، بقول لي يعني أنا يابا خلص يعني بجوز أروح بعد 5-6 سنين 3 سنين. بقول له ليش؟ بقول لي إداري هاي خلص يعني بتفوت والله بيعلم وين تروح، ما في تاريخ محدد للإفراج. يعني حتى بقى كل صورة 72 يوم، على الزيارة الثانية 96 باليوم عد فيهم. فلما خزن أول 4 شهور فلما رد جددت قال لي تقعد خلاص يعني في أخرى مش راح يبلتوني لا بسنة ولا سنتين. عنده يأس صار بالنسبة لده لأنه ما في عنده تهمة. لو في عنده تهمة معينة في عقاب معين ببين بعد سنة بتروح بعد سنتين بعد 10 سنين، أما إداري مش مبين. إن شاء الله تعالى بنتي المحكومية هاي ال4 شهور وبنتي ب16/11، وإن شاء الله بروح بنحتفل بتاريخ ميلاده بصادف 16/11 وفي 18 سنة. نتمنى من الله إنه يعني شو نفرح تاني بفرحة واحدة.
Thanks everyone for taking a few minutes to watch that. There were a few reasons we wanted to show this video in particular and hear from Mohammed Mansour. Not the least of which is the fact that he is from Jenin and he was arrested from his home in Jenin. And I'm sure everybody is familiar with the massive Israeli military incursion that happened in Jenin earlier this week. And this video, I think, is a reminder that these military incursions do not happen in a vacuum. It is not a one-off event. These are ongoing invasions by the Israeli military into Palestinian communities, even when they do not make international headlines. Mohammed was first detained without charge from his home in Jenin on April 9th, 2021, when he was 17 years old, and he was not released until June 6th, 2022. So that's a little bit more than a year. It's 423 days total where he was detained in administrative detention without charge or trial and held on secret evidence by Israeli authorities. The first administrative detention order against Mohammed was 6 months. And at the end of that 6 months, it was renewed for another 4 months. And at the end of that 4 months, it was renewed for yet another 4 months. And at the end of each of these orders, he nor his family had any idea whether or not he would be released at the end of that order or issued an additional administrative detention order, which he talked a little bit about in the video, of like that fear of not knowing if you're going to get to go home the next day or you will be continued to be detained indefinitely. When Mohammed was detained from his home in Jenin, it was in the middle of the night. And according to DCI Palestine's documentation, about 60% of Palestinian children detained by the Israeli military are arrested from their homes in the middle of the night. He was initially detained for 15 days at Israel's Huwara Detention Center, which is located in the northern occupied West Bank. And we've heard from many Palestinian children that the conditions at this particular detention and interrogation center are very inhumane. When Mohammed was arrested in the middle of the night from his home, he was struck with a soldier's rifle. He was blindfolded. His hands were bound behind his back and forced into the back of an Israeli military vehicle, where he was forced to lay down on the floor for several hours while Israeli forces transferred him to an interrogation center. At that moment, when it was 2 or 3 in the morning, he didn't know where he was going, and his parents didn't know where he was going. In the affidavit and the statements we've taken from Mohammed, he described this feeling as he felt like he was being kidnapped from his home in the middle of the night. After he arrived to the Israeli interrogation center, he was interrogated by an adult Israeli interrogator while his feet were shackled. The interrogator used coercive methods to attempt to extract a confession from him, which is very common with the documentation that we collect from Palestinian children who are being interrogated by the Israeli military. When we learned of Mohammed's administrative detention, DCI Palestine submitted a petition to the UN Working Group on Arbitrary Detention on his behalf. And the working group replied with an opinion that Mohammed's detention was arbitrary and falls within categories 1, 3, and 5. So that's lack of a legal basis for an arrest. There was no warrant. He was just taken from his home on suspicion in the middle of the night. There were no fair trial guarantees. He was not even charged with a crime. And he was discriminated against based on his national, ethnic, and social origin, as well as his gender. The vast majority of Palestinian children detained by the Israeli military are boys in a very clear pattern. So we share all this with you. As Brad said, this report has been many years in the making. And we're sharing this because we are very excited to sort of be bringing the No Way to Treat a Child campaign to the UK. And that is a campaign that we have been active in running for the last few years, mainly focused on the US, but are interested in expanding to other places in the world, in particular the UK, which PSC has sort of taken up leadership in propelling that forward. Myself, as well as Ayed Abu Aktaish, who is DCIP's Accountability Program Director, were able to travel to the UK in April of this year to meet with a number of MPs, including Andy McDonald, who is chairing this meeting. And we're very pleased to receive so much support from members of Parliament, as well as civil society groups and members of the public. So I think now we'll go to Rivka, who can talk a little bit more about what we're hoping to accomplish in the UK.
Hi, Rivka.
Hello,
Never-
hi,
Hi, over to you.
thanks. And thanks, Miranda and Brad, for your presentations and also for all of the work that both of you are doing and the entire team at DCI Palestine, which is doing such important monitoring work and the advocacy work. And it's just such a gift and really an honor to hear from both of you and to see this new report coming out, which is really, I think, cutting edge in the analysis, and hopefully we'll be able to do a lot of good work for it here. I just want to say a few short things. I won't take up very much time because I know that we want to have time for question and answer, but I mean, as Miranda was just saying, I think we have a really great opportunity right now to raise some of the issues that we've heard about today and the broader issues of protection for Palestinian children here in the UK and especially in Parliament. And we're really pleased to be working on our sort of local element of the No Way to Treat a Child campaign, together with, led by DCI, of course, but together with a very exciting coalition of partners that includes the Palestine Solidarity Campaign, of course, Amnesty International UK, ICAD UK, War on Want, Unison and the National Education Union, NEU, Caabu and Amos Trust. So a really broad group of partners, and certainly in particular having, I think, the trade union partners involved in this, especially the education union, is such an important part of the work we do, because so many of the issues that we're talking about really do have to do with education and children's safety and well-being in general. So just to say, over the next few months, we've got plans to take forward these discussions, both about this new report, but also the larger issues around the rights of Palestinian children with the resources that we have here in Britain. And I think to be able to do that in Parliament is a really important part of what we want to do. So we're looking to have a big push around this after summer and after the conference recess in the fall, including a national lobby day where we'll have opportunities, I think, for PSC members and members of all of those other organizations, members of the public, to be talking directly with their MPs about these issues in the fall, and other events that we can do in Parliament also in terms of, awareness raising, but also looking at particular things that parliamentarians can be taking forward in terms of action in support of Palestinian children. And part of that, the work that we want to do is to make this a bit of a, rather than a one-off event, we want to be doing a series and really looking at the ways that we can take this forward in a sustained way, which I think there's a lot of interest in. So we are looking to expand the list of MPs who we're speaking to about this. So I'm really pleased to see people here today. Of course, the unfaltering support of Andy McDonald is so important, and to see people from other offices here also as well. I think Brad and Miranda and other people from DCI are always willing to have individual conversations with other MPs too, which we're happy to help facilitate to spread the word and to make this campaign as big as we possibly can. So I think I'll stop there. But thanks again for hosting the event, and of course, thanks Miranda and Brad for all of the work that you're doing.
Rivka, thank you so much for that. I think that was really a good way to round out the speakers' contributions, because it's the actions that we now take. And just to reinforce the point, there are MPs' offices from the UK, from all parties represented here, and if not today, then certainly at our meetings, and there's some, and that's why this is such a powerful lobby, that it secures support from right across the political spectrum. So it's great to see colleagues either here or represented. I do want to encourage people to think about how we could prosecute the points we're trying to make. The fact that we're going to be doing something specific in the autumn is really good. All I would ask is that we give as much foresight of that as we possibly can. I know colleagues on the call will be thinking that we should perhaps include in that programme certainly a Westminster Hall debate, and the longer we can have that debate, the better. I do think that colleagues on this call and beyond, as we progress towards that date, we need to do a little bit of coordination around it, because what will often happen in those circumstances when we're holding a minister to account, there will be a great deal of repetition. It would be very useful to disseminate this report and go through the particular points quite methodically. And I don't know whether colleagues on the call would agree with me. We could share that work out amongst us. It would be a very good way to get that report disseminated and asking the minister to answer all of the specifics rather than just repeating one or 2 points, because I think that's probably important. I've just got a couple of questions, if I may kick it off, and I would encourage people to either raise their hands or come on the chat. But I just wanted to know a little bit about the role of the UN here in terms of any observations or interventions in terms of these detentions. I'm interested if anybody can speak to the physical relocation of these young men, these children, and the dislocation from their families, because I haven't got an understanding of where they're shipped to. The transportation of young people is illegal, and if you could say something about that, that would be extremely useful. And we heard different sentences being referred to. I'd like to know a little bit more about the lengths of. Hopefully, the report does detail the lengths of these sentences. But I can't think of anything more cruel than to be up against the prison gate, as it were, and then to be told you're getting a further 4 months. But this is, as I said before, perfectly sinister and absolutely designed to crush people's mentality and resolve. And they know exactly what they're doing. So I'd throw it back to the panel if they could come back to me on one or two of those points I make. Miranda, Brad, Rivka, do please come back at me.
Sure, and I can respond first. The question on the UN is the subject of probably a whole nother 2-hour discussion or more. But I think in 2013, UNICEF came out with a really important report detailing the ill treatment and violations that Palestinian children face in the Israeli military detention system. They had good intentions, came out kind of with that robust report, and it included 38 specific recommendations. And they set out to, work with the Israeli authorities to implement those 38 recommendations. Israeli authorities had no interest in implementing those. It became clear that the Israeli military was sort of engaging with UNICEF in an attempt to explain away the context, the violations, and all of that dialogue and sort of everything that UNICEF set out to do crumbled. And essentially, where it stands now is that UNICEF does very little publicly on child detention issues, and that's sort of been, I'd say, the case since 2015, 2016. They're not sort of taking that leading role, which they staked out in February 2013 with that report. I think the other pieces on the UN side are there's the special representative for the Secretary General on Children in Armed Conflict. We've pushed previously in 2015 to have Israeli forces included on the blacklist of the Secretary General's annual report, in part for killing and maiming, but then also detention, ill treatment is part of what the monitoring on the ground and the evidence base that goes into that reporting on the Children in Armed Conflict agenda. Again, year after year, Israel's been excluded from that list, in a way that has politicized the entire process and really taking a very strong, one of the strongest UN mechanisms that actually had some teeth and some follow-up and some sort of legitimacy in enforcing different rights respecting actions on the ground, is just completely gutted it. at this point. I think you have other agencies on the ground from UNRWA, who works in the refugee camps, right? They monitor and track detentions because, as we've seen in the past few days in Jenin, the Israeli military regular incursions into the refugee camps, and primarily, there are search and arrest operations where children are also detained, interrogated, and prosecuted in the military court system. So UNRWA, has information, collects information, and then OCHA, UN Office for the Coordination of Humanitarian Affairs, is also, collecting information. There's no shortage of documentation, right? There's a shortage of political will and sort of energy and momentum to really do something to address what the issues are. Everybody's documenting, everybody's collecting the information. We know exactly what happens in every different context. It's really the lack of political will to find solutions and force changes that really, challenge Israeli impunity on these issues.
Brad, could I interject there? Because what you've said is really very, very powerful. And I think it would be useful if we could have a brief note for parliamentarians about those exceptions, especially that you touched upon. But it also, colleagues, I don't know whether we can think about pursuing parliamentary questions, because we want to know what our ministers are saying, what their engagements are with the various UN bodies in this regard. I think we need to, I'm speaking colleagues, I'm speaking from a UK parliamentary perspective. I want to understand how we can put pressure on our ministers to answer these charges. We've just had the anti-boycott bill second reading, which again gave exceptionality to Israel. It seems that this is not the first time, and Brad's illuminating us about that. I'd just like to understand that a little bit better so that we can make those arguments and at least force ministers to give it attention, because I think it's been sadly lacking. Sorry to interrupt you, Brad.
Yeah, no, that's noted, and we can follow up with sort of a briefing note on that front. So your other questions on the physical relocation, it's I didn't mention it, but in 2022, of the cases that we documented, around 70% of children were transferred into prisons inside Israel. So in the video that Miranda played, I don't think it said it in the subtitles, but both of those children were held at Megiddo prison, which is just north of the West Bank, north of Jenin. In the same way that Israeli settlers, Israeli civilians, being transferred into occupied territory is in violation of international law and a war crime. It goes the same the other way. So Palestinian children, Palestinian prisoners being transferred out of occupied territory to serve sentences or for any purpose, really, that's also a war crime. So that physical relocation, obviously, aside from being an unlawful transfer, it prohibits the ability of families to visit. Visits are coordinated by the Red Cross, and they're arduous trips. Once you have the documents that you need, that's assuming you get the documents you need. The trips to visit family members inside Israel are exhausting, 12-hour, 14-hour trips, days. It's grueling. And then just quickly, as time's short, on the sentences, Andy, we don't include a specific sort of robust detail of the sentences in this report, but we have that information, and we do want to sort of look at sentencing, which includes fines, time, custodial sentences, but also suspended sentences, right? So even when a child gets out of serving a term, right, they usually have the suspended sentence where if they're arrested and charged with the same thing, right, they automatically serve that suspended sentence. One of the main problems with that, amongst all the problems with the suspended sentences, is that they usually are, they carry past a child's 18th birthday. So there's really no distinction between offenses alleged to be committed as a child versus sort of the, attaining the age of majority and what maybe follows you in adulthood. There's no real distinction there at all under the Israeli military law. But sentences generally, I think on the administrative detention side, it's usually 6-month orders renewed multiple times, is the Mohammed Mansour's case. That's very sort of emblematic of a typical case. We've had some successful challenges where a 6-month order will be reduced to 4 months, but then that 4-month order is then renewed multiple times too. So it's all quite indefinite, right? And whether you have a 4-month order, a 6-month order, a 2-month order, they can be renewed indefinitely, like as many times as Israeli authorities want under the Israeli military law, so that the time doesn't matter, right? And as you heard from Mohammed, he's thinking that he's going to be released, and then it gets renewed, and that crushes that hope, right? And really does, I think, have a psychological impact on the child that's compounded, obviously, by the custodial detention that they're experiencing, and separation from their family. The other piece just on sentences is, there's many children that reach the age of majority while they're being administratively detained. They have their 18th birthday, and then it's renewed and renewed, and then because they've now, become 18 years old, right, then they're treated as an adult. So then the renewals sometimes look different. They're longer, multiple times than if they were a 15-year-old or a 16-year-old. So there's a number of different factors that go into the sentences, but really there's no, overwhelmingly in the administrative detention context, or just the typical case of a 14, 15-year-old child alleged to have thrown a stone, custodial detention is the norm, right? Generally kids spend, a month to several months in prison in pretrial custodial detention. And then ultimately, right, a plea bargain will be accepted by the military prosecutor and the judge for time served, or, maybe they have an extended sentence beyond that. But children plead guilty because it's the fastest way to get out of the system. So there's more to come on sentences, but I'll leave it there for now.
Thanks very much. I know Rivka wants to come in at this point. Rivka, do you want to contribute?
Yeah, just a quick thing to add to what Brad has said about the issue of transferring children detained into prisons outside the occupied territory into prisons in Israel. This is something that the FCDO has repeatedly mentioned in its human rights reports, its annual human rights reports, and mentioned in particular that it may amount to a war crime. So I think in raising questions to ministers, that's an important point to hold on to, because it has been recognized over and over, year by year, by the FCDO as an issue that they're watching, but we haven't seen, of course, any consequences emerge from it.
Yeah, okay, thanks, Rivka. It is quite remarkable that we're talking about war crimes, human rights abuses, and the failure to abide by international law, and it seems that that is ordinary fare so far as Palestine is concerned. It's just it is beyond imagining, really. I would comment that, of course, we do have an ongoing trade treaty under discussion with Israel, and the point was raised from not from the opposition benches. It wasn't from the SNP, Liberals or Labour or anybody else. It was from the Tory party, a certain flamboyant, benighted Tory member of Parliament who raised the very sensible question of what leverage is the UK able to apply given the environment of these trade talks. And I think that does present us with an opportunity to keep pressing these issues. It's a cause of great embarrassment for the United Kingdom government to be continually pressed on these issues. But I regret to say that I've been in the UK Parliament since 2012, and all I've had consistently, all anybody's ever had, is just a repetition of some rather anodyne words at the dispatch box that the United Kingdom government lets Israel know just how displeased it is with their behaviours and does absolutely nothing by way of any meaningful measures, sanctions or otherwise. And you can sense the frustration from within inside the Parliament that our government isn't responding in anything like an appropriate way, and will continue to press the case. With that, colleagues, we do have a link to the report that was circulated in the chat. I think Miranda and Brad, we will probably be emailed as well with it, I assume. Is there anything else that you'll be communicating to us over the coming days and weeks? Presumably you'll be sending us that. But those other points that I've raised opposite the roles of or the failures of the various UN bodies and the exemptions would be very, very useful. And certainly some sort of timetable around our activities in the autumn and the bodies that we want to press with. I think do as much of that as we possibly can to make it as effective as possible, and that would be great. Liz has just flagged something up in the chat as to tell us that the Save the Children has a new report on Israeli military detention. That's on Monday. Oh well, that is going to be really useful. Liz, do you want to speak to that? Do you want to speak a little bit about that?
Hi, I can do very briefly, yeah. It's embargoed at the moment, but there's so much overlap with what we've just heard from DCIP, who are very good, close friends and partners of Save the Children operationally in the West Bank as well. So we're going to be announcing as part of that report a new policy call on the UK government, which is to press the government of Israel to agree a full moratorium on holding children in military detention unless and until that system is brought in line with the international laws and child rights standards that have been outlined as part of this discussion. So the idea was to come up with something practical that the UK could do, and which, based on their response to our previous report and to some previous efforts from parliamentarians, we think is potentially realistic. Because Andrew Mitchell, James Cleverly, when he was Middle East Minister, they made some of the right noises on this topic. The government has been doing some things behind the scenes to try and persuade the Israelis to improve practices around things like avoidance of night raids, avoidance of handcuffing children, etc. But it's just it's just been nowhere close to enough to actually to tip the balance and get the government of Israel to fundamentally change the system. So what we'd like to see the UK government do is, rather than kind of warm words and trying to secure a few tweaks to the system, really use this very close relationship it has with the government of Israel to actually bring about a meaningful change that implements those UNICEF recommendations and brings the system in line with international law. So that's what we're going to be advocating for as part of this report, which, as I say, is embargoed at this point. But it's based on some very powerful and hard-hitting interviews with former child detainees and their parents.
Yeah, thanks very much for that contribution, Liz. That's really useful. I think that whole business about making this very personal and graphic is very important. I'll start to draw the meeting to a close. I want to thank our speakers because that was incredibly informative, and I certainly look forward to reading the report in further detail. I just explained that the reason my father was a conscript in 1945 to 1947, and he always thought that the Palestinian people had a really raw deal. He loved them dearly, and I saw something on Twitter this very day that was reporting about the capture by then were called terrorists, went on to be Israeli leaders and prime ministers, and the treatment they meted out to the British soldiers. I thought that was quite an interesting position. This week has been bookended by these crimes against these children, and I in my contribution earlier this week on the floor of the House of Commons, I actually read the names of the two boys that we knew about, because I think it's so easy for the British media and the consciousness, I'm not blaming the media, the consciousness to simply dismiss this as Palestinians and numbers of Palestinians. and not thinking about what that meant in terms of the violence visited upon them. You know, a gunshot through the chest that ripped that poor boy apart, a bullet through the head that just exploded his life and extinguished it in a microsecond, and a mother having to pick that child up. And I thought, we're having this discussion today. It is truly barbaric, and I think we've got to just completely commit to this cause, and it is relentless. We've all been at this for years. I'm not suggesting for one single second this is going to be over with quickly. We know that not to be true, but I do feel it's a duty. I stood in that hot yard in Jericho when Joe took me, when that young father of a boy who was detained, when I told him he was a British parliamentarian, he said, "This is your fault. This is your country's fault." They have not forgotten how that came about and how the land of Palestine was divided. And I tried to stress the point in our parliament that we do have a historical and moral responsibility here. And for those reasons and many, many more, I know many of us right across the political spectrum in the UK and of course beyond. We've got colleagues from Belgium and Ireland, I think, have been signed up for this call. And I think if we can commit to that and share that responsibility, we'll be much more effective. So please keep going, colleagues, and thank you so much for this extra special session today. It's been tremendously informative and powerful, and we must keep going. And with that, I'll close the meeting and thank you all for spending time, your precious time today, and no doubt we'll gather again soonest. Thank you very much indeed. Okay, thanks now. Bye-bye. Bye-bye.